If you've had a few drinks less than 2 hours after driving, you can be charged. This is one of the most bizarre takeaways from the new drinking and driving legislation across Canada that just went into effect, where if you were behind the wheel of a car and then you went into a bar and had a few drinks, or even if you went to your own home and got drunk, police could demand a breath test and charge you if you blow over or charge you if you refuse to comply. In your own home, when you're there for the night, your car is parked and you haven't been driving for an hour and a half. This is meant to take away the ability for people to claim that they got drunk after they were driving and actually weren't driving drunk. But what this legislation truly does is open the door to a whole bunch of overzealousness that police are able to employ. And what's worse is that despite the protestations of the Ontario Criminal Lawyers Association, pretty much every constitutional lawyer imaginable, civil liberties groups, all of whom say that this will cause people to have limited rights in their own homes and to have to prove their own innocence, police are still saying, oh, no, just trust us. Now, don't get me wrong, I'm very pro-police generally. They have a job to do. Unfortunately, police are very fond of the freedom and power this gives them and the latitude this gives them, even if civil liberties take a hit under it. So, for example, when an Edmonton police spokesperson says, no, they're only going to go and demand a breath test if they have reasonable suspicion, that's truly the opposite of what the legislation says. Police used to require reasonable suspicion, which is already a lower threshold than probable cause. Now that suspicion is gone. They can just, on a whim, decide they want to subject you to a breath test. The problem with this is that it allows police to go on a fishing expedition for people who have done nothing wrong, to basically allow police to try to find something you might have done wrong. Even in this case, there's nothing morally, nor should there be anything legally wrong with having a few drinks at home when you have no intention of driving again. A lot of the people who have defended this legislation say that age-old trope, if you've got nothing to hide, you don't need to worry. Or, well, if you're not drinking and driving, you don't need to worry. The problem with laws that erode civil liberties is that they push everyone into a position where they have to defend themselves and prove their innocence. And that's precisely what's contained in this legislation. If police charge you with blowing over because you were in your home and you drove less than 2 hours ago, you have to prove that you were not drunk. How do you prove a negative? How do you prove that you were not drunk when you were driving behind the wheel, but you got drunk or at least mildly intoxicated after the fact? Now, don't get me wrong, everyone predicts that this legislation will be ruled unconstitutional, but it'll take years, countless amounts of money, government having to fight a long drawn-out battle for this to get all the way up to the Supreme Court before we get that definitive ruling. The much better approach would be if the people responsible for drafting this legislation wouldn't put something that has no respect for civil liberties in front of Parliament in the first place, and if Parliament wouldn't adopt these things. But again, the government stands by it, MAD, which is an activist group, is standing by it, and police are standing by it, but that's because it gives government power over you and I. For True North, I'm Andrew Lawton.